Welcome to ProLaw CLE. We strive for excellence and hope that you will enjoy today's presentation. If for any reason you experience issues during this CLE, please first try refreshing your browser. If your issue continues, please click on the Support tab in the chat window or contact Beacon Support at 772-297-2901 and we will resolve your issue right away. Thank you again and enjoy your CLE.
Good morning. I'm Erika Riggs, attorney and partner at Disability Law Group. Thank you for joining me today. So I have been handling Social Security disability benefits for my entire legal career, with over a decade of handling thousands of Social Security disability cases spanning the initial application through appeals to the U.S. District Court level. My hope and my goal is for every listener to take away even just one practice tip that you find helpful and can implement in your own practice. Whether you have been practicing law for one day or decades, or maybe just even exploring this area of law, I hope to give you some useful strategies that help the way that you help your clients. We will take a look at what is needed to establish disability, the process, which has been dramatically changing, particularly in the wake of the current COVID-19 pandemic, and what strategies are recommended in my experience to help not only streamline the process for you and your team, but also to help increase the chances of winning a Social Security disability case. Common themes that you may notice are those that I find most important in my day-to-day work, both professionally and personally. And those are preparedness, flexibility, communication, and compassion. All of these arenas affect how you practice law, the way you strategize, your reputation, and ultimately your representation of your clients. Now let's get that disclaimer there at the bottom out of the way. Please read and know that you can refer back to this PowerPoint at any time online on the ProCLE website, as well as reach out to me directly for any questions. Let's kick off this presentation by a brief overview of the benefits that we are discussing. There are many different disability benefits available, as I'm sure that you know, under the umbrella of Social Security. The most common ones, of course, being Title II disability benefits, Social Security disability insurance, or commonly called disability insurance benefits, and Title XVI SSI, or supplemental security income payments. While SSD benefits are derived from FICA taxes paid or work credits earned during the claimant's relevant working years, SSI payments come from the General Treasury Fund and are based on general financial need. We will be focusing on proving disability on the merits or medically rather than the technical criteria for purposes of this presentation. However, it is important to know about all of the different disability benefit programs offered and the technical criteria for each one. This is important first for strategy purposes, of course, so that you can advise your clients on what benefits that they can or could qualify for, but also so that your clients understand what their rights and options are. So for example, if your client is eligible for SSI payments, but you can tell that they may meet the criteria for disabled adult child or a child's disability benefits, where you must establish that the onset of their disability began before they reach age 22. However, they may not yet meet the technical criteria that's required for that program based on a triggering event for their parent or guardian becoming disabled, deceased, or on retirement. You should at least let the client know about the criteria for disabled adult child's benefits in the event that the triggering event happens so that they understand what they could qualify for. And this could mean a significantly greater benefit for the disabled adult child down the road. This is a perfect example of how being prepared, thinking strategically, and communicating with your client can truly help that person. And it affects your reputation as well in the way that you are providing comprehensive and compassionate legal advice and representation. And people remember that. Your clients are thankful and now they understand what their rights are, and I think judges pick up on that as well. Now, there's a 5-step process for proving disability at any stage, including at the hearing level. And the first is substantial gainful activity, or SGA. If a claimant is working full-time or performing work at substantial gainful activity levels, even if not full-time, then the individual will not be eligible for disability benefits, with some narrow exceptions. For 2021, SGA is $1,310 per month gross income, or $2,190 gross monthly earnings for a blind individual. Step 2 is a severe impairment. There must be at least one medically determinable impairment that is capable of producing significant work-related limitations. When we talk about limitations, think exertionally, such as the difficulty standing, walking, lifting, carrying, pushing, pulling, right? But also think about those non-exertional limitations, such as difficulty focusing, comprehending, understanding, difficulty seeing or hearing, maybe difficulty tolerating certain work environments, and manipulative or postural functions, for example. Also, the medical determinable impairment, to be severe, must have lasted or be expected to last for at least 1 year, or likely to result in death. Now, note here that some denials at step 2, maybe even more so during the pandemic, with the quicker processing of claims at the initial reconsideration and hearing level, may indicate that the condition is not severe because it hasn't lasted 1 year from the time that the claimant filed for disability benefits to the time of the decision. But you need to make sure to argue that expectancy prong. And this is where a medical source statement can help, especially early on in the process, and more to come on that later throughout the presentation, that your client's condition is not likely to improve, or is not responding well to treatment or medication, or has maybe even a poor prognosis, or for some other reason is just likely to last at least a year. The third prong is listing, and we will dive deeper into this throughout the presentation, but know that if your client's condition is so severe that it meets or medically equals the criteria of one of Social Security's Blue Book listing of impairments, then your client could be found disabled at step 3. However, I should note that this is rare, and a quick practice tip here: if it seems that medical improvement is perhaps likely down the road, I make sure to always argue disability at step 5 as well, so that the person is not likely to be cut off benefits if their condition improves at step 3 to the extent that maybe they no longer meet or medically equal that listing, but they're still disabled nonetheless. Now, if your client is not engaged in SGA, has a severe impairment, but not considered to be so severe that it meets or medically equals one of the listings at step 3, the analysis will then move forward to steps 4 and 5. Step 4 is past relevant work. If the claimant is found capable of performing their past work that they have done at SGA over the last 15 years, or the relevant time period, then they are found to be not disabled. However, if they are found to be unable to perform their past relevant work, then the analysis would move to the last part, unless, of course, a medical vocational rule applies that would direct a finding of disabled. So step 5 is other work. So if the claimant is found capable of performing other work, even if they cannot do their past relevant work, they may be found not disabled. Once again, unless there is an exception under medical vocational rule. Otherwise, if they are found incapable of performing their past relevant work and all other work due to severe impairments, then they would be approved for disability benefits. So how did we get here to this hearing level, and what's to come next? First, here are the stages of appeal to get to that hearing and through the appeal level at the U.S. District Court, with the required forms noted in this slide. Note that all of these appeals can be perfected online within the deadline, of course. Always communicate those deadlines to your clients in written correspondences, which is where your case management software comes into play. The question is not if you should have a case management software, but perhaps which one you should have. And your software should allow you to track statutes and deadlines, to save communications and correspondences with your clients, the field offices, and more. Ultimately, it should make your life easier. We use ours to have certain documents saved for each client, such as representative documents, authorizations, requests for records, letters that we send to the clients or to the courts, our briefs, and more. So that way we can merge any templates that we need that can then be auto-filled with information we designate to help save you time and energy. And saving communications in the client's file can come in especially handy if you need to do a fee petition, for example, to document your work and communications all in one spot. Or if you are not copied on a decision or a correspondence, you will be able to track everything that you need to and also show proof of your diligent efforts to follow up on a decision, for example, and the evidence that you have received, who you talked to, and when. So there's no need to reinvent the wheel every time. If you spend the time to plan ahead and save the documents that you know you will need for other clients in one easy-to-find spot, it makes your life easier and it will make your practice run more smoothly. Now, we have all likely experienced in one way or another when things don't go smoothly, or just how awful it is when you are not prepared for something, right? When you can't find what you need, or perhaps maybe you are fighting change or resisting new ways of doing things, as is common the case with new technology, for example. So I challenge you to think about how you deal with change. Think of how you dealt with the pandemic in the early stage. How, if at all, did you modify the way you handled your practice? Did you or did your firm leverage technology to help better serve your clients and even support your staff? Or did you remain stagnant and not really do anything different other than just not go to court? Or maybe you fell somewhere in between. I think that the pandemic has shown us all just how critically important it is to remain open-minded and flexible to change, strategize ways that you can use technology or new processes and forms, some of which we'll talk about here soon, to your advantage, and even improve upon your systems and communications in such a way that helps you. Now, they say failing to plan is planning to fail, and I'm sure you couldn't agree with me more there. I have found that in my practice that we can leverage technologies in ways that makes it easier for our staff to continue working remote while still holding virtual meetings and communicate important changes with them and updates. So again, if your staff feels supported and prepared, they are better equipped to help you and also to help your clients. I love this quote here from Maya Angelou, and I think it's especially fitting here for us. I'm sure you would agree, again, that when you're prepared and you're receptive to change, it's easier to enjoy what you do and to be successful at it. Our work helping people with disabilities can be especially rewarding work, and it's truly an opportunity for you to help someone that is quite likely in the most vulnerable time of their life. They are leaning on you and your team to help them, to guide them, to help obtain the benefits that they need, which for many can be a lifeline. The monetary benefit that comes with disability benefits in terms of any past due benefits and or future monthly benefits, in addition to insurance, such as Medicaid for SSI and Medicare for SSD, can be the difference between keeping a roof over your head or living on the streets, or keeping your car to get to your doctor's appointments, or insurance to have that life-saving medication. Even if not that extreme, the help that we provide can impact that client and their family for the rest of their lives. Especially so now with COVID-19 and our client base being more likely to be at risk, the potential for impact of our representation can be life-changing. Compassionate representation stems from truly enjoying what you do and realizing the impact potential of our work. Now, I think in addition to providing compassionate representation, one of our most, if not, the most important roles that we have as a disability attorney is to develop the record and constantly strategize what evidence is needed to help support disability in each case. Claimants now receive an ADL packet and function reports, both at the initial and reconsideration level here in Michigan. These are opportunities for you to help guide your client and help them understand what areas to focus on. Let them know that these reports are coming in the first place. If your client is 50 years of age or older and the medical vocational rules apply, then that work history form becomes especially important. And you're going to want to advise your client to answer those questions honestly, but you can caution them to focus on the physical demands of their past work, for example, and not to minimize those on that form when discussing their job history. The more that you communicate the process, including the next steps and what to expect with your client, the more prepared that they will be. And I have found that this will actually in turn reduce calls and confusion throughout the process as well. Now, every case is different, even if the impairments are the same. And it's incumbent upon us to ensure that the evidence needed is requested. And that begins at intake, and it continues throughout the life of a case. When you have a strong intake process that asks those relevant questions for what evidence might be needed, it increases the chance that you are taking on a stronger case and also building the right kind of evidence. Ask about whether the client attempted to work again after the alleged onset date, especially if you are filing that application for them and need to strategize what that onset date should be, or if you are thinking about amending the onset date at the hearing level. Perhaps they were in school or incarcerated during the relevant time frame. You will want to see records that may be available that could document symptoms and limitations, difficulties they have, and more. Is there someone that helps them significantly or possibly could write a letter in support? Make sure, if so, you obtain that. It has their names written, signed, and dated, and you want to get that into the record early. Ask if they are a veteran and if they receive any service-connected or non-service-connected pension disability benefits, as there may be a rating decision out there that could be helpful for their case. You can have them send it to you. Also ask if there was a compensation and pension examination conducted, or many times for veterans, a vocational rehabilitation assessment that was done in connection with their VA disability claim that you're going to want to know about. Ask about any workers' compensation or whether short-term and long-term disability benefits were in play. Maybe there was an internal medical examination or other medical records aside from just the treatment providers, for example. There are many ways that you can add evidence into the file to help your client. And the more evidence that you have, the more you know about the case and the better equipped you are to be able to advocate for your client. Now, there are lots of options here for medical source statements, which we touched on earlier. But the goal, again, is to have a full and complete file, building the evidence needed to help support disability for your client so that we can be on the same page and so that there are no surprises come time for the hearing, which could result in further unnecessary delays. Here listed in this slide are some examples of what you would ideally want to include in a medical source statement, or what you're going to want answers from the client's doctors that are completing the forms, focusing, of course, on limitations regarding their ability to work for adult disability cases. So think about all evidence and get creative. One approach is not going to work for every single client. It's best to start crafting and perfecting, building that evidence chain like we talked about at intake. Make sure that your team asks about various factors that may be in play that could impact their case positively or negatively. Not only could this information gathering benefit you in your practice by ensuring that you know what you need to, but also helps create a stronger intake. Can weed out those cases that perhaps are not ideal for you or your firm and enhance the quality of those that you take. Again, the more information you have and the more you know at the outset, the better you are able to represent that person. Now, it's important that you know what standard we're talking about that's involved when evaluating a medical source statement. Social Security will not defer or give any specific evidentiary weight, including controlling weight, to any medical opinions or prior administrative findings, including those from your medical sources for claims that are filed after March 27 of 2017 under 404.1520C. Under this new code, medical source statements are now evaluated based on how persuasive they are. To that end, the most important factors to keep in mind when drafting and considering the persuasiveness of medical opinions are supportability and consistency of the opinions with substantial evidence of record. In addition to other factors such as the treating and examining relationship with the claimant, how long the claimant or patient has been under their care, and what has been the purpose and extent of the treatment and degree of specialization of the provider who completed the form. So an example is if the main medical determinable impairment is cardiac in nature, and the opinion or medical source statement is from the client's treating cardiologist, who has treated the client for the entire longitudinal period at issue for the case, maybe even longer, and the opinion details findings that are consistent with the objective tests, such as an echocardiogram, stress test, maybe a cardiac catheterization, and supported by the routine subjective complaints that are noted in the treatment records, like shortness of breath, even at rest, chest pain, fatigue, and the need to nap during the day, well, then that sounds pretty supportive and persuasive to me, and I would argue the same. Or by contrast, is the client not complaining really of any symptoms at all, and therefore no tests have really been ordered, and yet the opinion reflects limitations that are so great they just don't really find any support or foundation in substantial evidence, not really sounding so supportive. So note that while a report or statement by a nurse practitioner, mental health therapist, or other non-physician may not be deemed an acceptable medical source under current case law and regulations, the opinions from any source must still be evaluated under 404.1520C, considering these factors, and they still could be found persuasive. Now, we talked briefly earlier about listings at step 3 of the sequential evaluation process. I also want to talk about it briefly here as part of your strategy when considering drafting medical source statement templates, especially if you think that your client's conditions could meet or medically equal the criteria of one or more of the enumerated listings. I have included a few common listings I typically argue here in this slide, but there are, of course, others. First, it's imperative that you familiarize yourself with the listings, both adult and children if you take kids' cases, to understand when there may be an argument to raise regarding a listing being met or medically equaled. Then, if you have a template drafted that your staff can send to clients' medical providers regarding the listing, if appropriate, you can introduce that statement as new evidence to help support disability at step 3, especially if your client's conditions does not quite meet but likely could medically equal the symptom severity or similar criteria noted in a listing. And leave space for the doctor to indicate rationale for their opinion or how they arrived to their opinion. Ask them by directing such questions in the form itself to indicate any specific tests or exams or other objective evidence that they have relied on to come to their opinion. Now, of course, a more generic physical or mental medical statement can work just fine, but it can be helpful to have templates drafted that you can use for future clients who, again, might meet or medically equal a listing. And they don't need to be overly lengthy. You can get the job done with a 1 or 2 page document that, as long as it indicates those pertinent limitations and whether the client's conditions meet or medically equal a listing, considering those relevant factors that will be considered in evaluating the persuasiveness of that opinion. Now, as you are no doubt aware, medical evidence is critically important, and communication with your client is also necessary to effectively represent them and make sure that you're both on the same page. The more that you know about their treatment and relevant medical updates along the way, the better. When your client feels like you are in good communication with them, guess what happens? They are less likely to be upset with you or call frequently. And they are more likely, of course, to be happy with you and your firm, and maybe even refer others to you or leave a good review for you. Attorneys get a bad rap for, let's call it lack of communication skills. It doesn't mean that you have to call every client you have every single week or even every month for that matter, but you should check in on them from time to time. A quick practice tip here. We use our case management software to set a diary or task that we call a triage call for the attorney or paralegal to review the case every few months and just take a good look at what might be needed. Maybe you lost contact with the client, in which case you should document those efforts to maintain good communication and a client-attorney relationship. But use that review call as an opportunity to check in with your client. If you have not heard from them in a while, maybe they forgot to notify you of some important medical updates. And as a reminder to your client to stay up to date with treatment and to notify your staff of any changes, and also provide them with a status update so that they know what's going on with their case and what's to come next. Now, this is also an opportunity to issue spot for any potential non-compliance issues. If you have been practicing a while or have received any denials or unfavorable decisions from an ALJ, you may have noticed that if there was any indication of non-compliance noted in the record, it was likely documented as such in the decision, especially as a reason for finding the client's testimony or subjective symptoms less persuasive, for example. Now, unfortunately, non-compliance has seemed to become an even bigger issue since the pandemic started just over a year ago with COVID-19, which has made it difficult for many people to see their doctors or specialists and remain compliant with treatment. So how do we approach this issue if it comes up for one of your clients or even before? If there is evidence of non-compliance or failure to follow prescribed treatment, such as medications, physical therapy, injections, maybe a referral to see a specialist or have surgery done, you're going to want to look at SSR 18-3P for guidance to help answer the questions of whether following such treatment would expect to restore the person's ability to otherwise perform substantial gainful activity level work, which in my opinion is quite vague, never mind difficult to speculate on, but nevertheless it must be considered here, and also whether there exists good cause for your client's failure to follow through with that treatment. Ultimately, this analysis is reserved to the commissioner or adjudicator, and there is not much guidance here, but note that a medical source statement that details your client's prognosis, for example, could be helpful. Again, if the prognosis is poor even with treatment, or they have a chronic condition not likely to improve, then of course I would argue that is helpful in answering that first prong, and look to what the medical records say about response to other treatment tried to help raise those arguments. I think the more common issue here and opportunity for argument in support of your client's failure to follow prescribed treatment falls within the proof that you have regarding good cause. Examples of good cause under SSR 18-3P include the ones that you see here on this slide, but note that you could still argue others as well. You're not limited to this list. These are probably the most common examples. So if you have a situation, probably more likely is not able to afford treatment, perhaps they are not on Medicaid, or their insurance just won't cover the entire amount of treatment, such as surgery, for example, and they just cannot afford these costs out of pocket. This regulation could protect your client, and it's up to us as advocates to make sure that we raise those arguments for them. Now, sometimes this proof is actually indicated in the record. You may see it noted by a doctor or nurse, for example, that the patient cannot afford the cost of certain treatment, or perhaps they do not have the ability to properly care for themselves post-operatively as required. Or maybe they are just too fearful of having treatment based on what happened to their sister or their friend, and that is noted somewhere in the record. Don't just assume that Social Security or the administrative law judge has read or knows that this is in fact in the record. And the opposite is also true. Don't just assume that because there's no rationale indicated specifically in the record for such alleged noncompliance that there must not be a legitimate reason for it. Instead, talk to your clients about this and bring the reason for good cause, if there is one, up in your brief or in advocating for your client during their hearing. You can use that as an opportunity in your opening or closing statement, for example, and we're going to cover that shortly. However, note that if the sole reason is the fear of surgery based on knowing someone else where treatment or surgery was not successful, Social Security will require a statement from the medical source that confirms your client's fear is so intense that the procedure or treatment would in fact be a contradiction to having that treatment or surgery. Also, if the surgery could come with a high risk of loss of life or limb, such as open heart surgery or organ transplant, then that reason alone would be sufficient good cause. But at the end of the day, the point is read the records and communicate with your clients so that you can help them and advocate for them in the best way possible. For those of us who have handled Social Security disability hearings beyond the last year, know that hearings have been in person, with the more recent development of allowing for the option to opt into video hearings. However, prior to the pandemic, the only video opt-in or VTC option required you and or the claimant to be inside of the facility or the Office of Hearings Operations to utilize their equipment in the office with an ALJ who could appear by video from another hearing office, maybe even in another state, which was commonly the case. But since March of 2020, almost exactly 1 year ago, the hearings offices have remained entirely closed to the public. Therefore, at first, there was no opportunity to have video hearing remotely, as no one is allowed in the hearing office and there was no established software or ability to hold hearings completely by video or virtually outside of the hearing office. Fortunately, the courts allowed for the opportunity to continue holding hearings. It has just been done by phone with a hearing monitor calling to connect all parties and anyone else that might be testifying. This has allowed the hearing office on a national level to bring down the backlog of cases that are awaiting hearing pretty significantly over the last year. As of recent, the Office of Hearing Operations have released their new software through Microsoft Teams that will allow claimants, attorneys to opt in to a video hearing and or a phone hearing. We are still not sure when or if the hearing offices will reopen to the public, but it's, I think, great that we have this option now for claimants who may choose to appear by video. Either way, for now, you must opt in to the option that you choose, and it's critical that you consider and counsel your clients on the option that is best for them individually, considering their case and their wishes. Now, copied here in this slide are the contents of the letter that the claimants and the representatives now receive once a request for hearing is filed, to indicate your response of opting into a phone hearing or video hearing or opting out entirely. Now, theoretically, you can see here that you can opt out of both phone and video hearings. However, that will mean a longer wait for your clients. Both options, phone and video, have been shown to be much quicker than waiting for a potential in-person hearing to happen. Clearly, that is the case now when we are, again, not sure when the hearing offices will resume hearings in person. Ultimately, waiting for an in-person hearing could mean an additional year or possibly even much longer, which, if you can think about the practical implications of that decision and wait time for your client, who may now be in dire financial need for benefits to help keep their home and stay in treatment, stay afloat, choosing to wait may not be a good practice, and I certainly would not recommend that, especially now when we have the option for the claimant to appear by video, which I would think would give a more personal feel to the process. Remember, this process and this decision is a big deal for claimants, and they ought to have their day in court and feel heard and have the opportunity to be seen as well should they choose. There is, of course, for both phone and video hearings, the possibility of technological problems, in which case the hearing office directors advise to stand by. The court staff will attempt to reconnect, and if needed, will be rescheduled if they just cannot resolve the tech issue, which I think would be rare. But when considering to have a video hearing over phone, talk to your client about whether they have internet, Wi-Fi, or hotspot, or if they're just maybe not tech savvy, although I will say they've made it very simple, or if the client is homeless. Now, I know some claimants have actually been able to partake in a phone hearing, and I believe a video hearing as well, even in their car. While not ideal, they are still able to have their hearing this way without any unnecessary delays. Also note that you can modify your request from a phone to a video hearing and vice versa, but the courts do ask that you give them some time before requesting that change. So don't do it the week of your hearing. And note that this process is continuously evolving. So what is true in terms of the processes and technologies today, as of the time of this presentation, may not be the case in a month or even, in a year from now. Always strategize how to strengthen claims. Think about what conditions your clients have and whether medical source statements have been received and submitted, as well as what evidence you can recommend adding to the case, such as letters in support or other action that might be needed or helpful to prove disability. Think about the earlier slides where we talked about other evidence that you can consider to make sure the file is complete, and also the issue spotting that takes place throughout, which again requires good communication with your client from the start. And finally, you must comply with Social Security's 5-day rule under 81 Federal Regulation 90987. Now here is an example of the template we use copied within this slide showing our efforts to provide notice of and obtain records for any relevant medical information to complete the file. Under this regulation, representatives and claimants are now required to provide notice of any medical facilities at least 5 business days before the scheduled hearing. There is no one way to do it, but this is an example of what we submit to comply with this more recent regulation. We send this correspondence via electronic upload, ERE, directly into the client's file, and a copy is mailed or emailed to each client in preparation for their court date. We send this early on at about the 2-week marker, and again at least 5 business days prior to the hearing as required to provide sufficient notice. Now this document is automatically generated in our case management software for each client once merged, so it doesn't take much work at all to do this for each client, and yet still complies with the law, and even goes a step further by communicating this to each client, which I like because this is another touch or opportunity for your client to review this document and say, oh wait, they're missing this facility or MRI or physical therapy I had done recently that I forgot to tell my attorney about. So it's like a backstop for you also. But more often than not, with good communication, your clients will review this and they're going to feel confident that you have requested and submitted all evidence needed to help support their case. Again, it's important that we review the case to determine what evidence is going to be needed. Set yourself a task or a diary to review, check in with your client. Also, draft a brief or legal memorandum outlining your theory of the case. And finally, prepare your client for what they can expect at the hearing. So you're going to want to review the format of the hearing. Is it by phone? Is it video? Or maybe one day back to being in person. Explain who is going to be made part of the hearing. Discuss questions that they can expect to be asked, like their work history, their impairments, their limitations, ADLs, or what they do on a typical day, their functioning level, and maybe any help that they need. Talk about the next steps with them, including the time frame for a decision and whether any post-hearing items might be needed. You're going to want to give your client reasonable expectations. I always say that hearing decisions typically take 2 to 3 months, although it could be quicker and it could be longer depending on the circumstance. Advise them that this process is non-adversarial. Your goal is to help calm their nerves and prepare them for what to expect. Not so much so that they are completely coached in their answers, but so that they are not completely caught off guard either as to the process. If they are prepared, chances are they will be able to give more helpful answers that are consistent with other important evidence of record, which is the goal, right? Like any medical source statements or their earlier function reports they completed. Also use this as an opportunity to review any red flags or issues like substance abuse or non-compliance with treatment, earnings after the alleged onset date, or any other issues that may be raised by the record that might come up during the hearing. Now, during the hearing, you're going to want to clear up any housekeeping matters or procedural issues. So, for example, do you need to make clear that there is an amendment to the onset date based on earnings or based on the medical evidence or another reason, after, of course, obtaining your client's consent? Are there records outstanding that may require the record to be held open for consideration before a decision is rendered? Bring them up early and have an outline of questions for the claimant or any other witnesses, like a medical expert or vocational expert, at least a rough draft of questions to ask or any hypotheticals that you might want to pose to the vocational expert. It's also a good idea to have an opening or closing statement regarding your theory of the case key arguments that you need to raise during the hearing written down ahead of time. Especially as you are starting off in this area of law, some judges might even ask you to provide an opening or closing statement, and you're going to want to be prepared. Develop the record. Make sure to ask questions that could help clarify or highlight the strength of your client's case. Get ahead of those issues. And remember that this is a chance to showcase your own style of questioning and your knowledge of the law and of the case. Your questions should be direct enough and to the point, but also purposeful. Think about the questions that were not already asked that could help prove disability for your client. Again, task or diary for any post-hearing items that might be needed so that you can meet any deadlines, and have good post-hearing notes that could make your life easier, especially in the event that you may need to file an appeal. And finally, debrief. After the hearing, talk to your client about what actually happened at the hearing and what the next steps, in fact, are. Reassure your client as to how they did. The last thing that you want is a worried client feeling like they just completely ruined their case by what they said. Hopefully that's not the case, but you're going to want to review the next steps and answer any questions that they have. Remember that communication is key and helps the clients feel supported and well represented. Remember that the work that we do is important and it's impactful. The compassion, time, and effort that you devote to your clients' cases matter and can affect outcomes. This is so important. The time and energy that you devote to the case, it shows. Your staff can feel it, the judges can tell, your clients know. Take the time to put into action processes and strategies that will help make your practice easier, less stressful, and more enjoyable, so that you can devote your time to what is needed most. So at this point, I'm going to answer a few of the questions that came through, best I can, time permitting. And one of them is regarding briefs, best practices, and tips for drafting helpful briefs. First, I would say get in the habit of writing them because they help clarify your theory of the case, and the judges appreciate them. Over the last decade, I have yet to have an ALJ tell me that they did not want a brief or they didn't appreciate my brief, but I have heard many a times a judge thank me in front of my client for preparing a brief in their case. You will want to make sure that your brief outlines the pertinent procedural history. If you are going to make, again, an amendment to the alleged onset date, you're going to discuss that with your client ahead of time, and with their approval, try to make that amendment early on in a brief so that the judge knows before the day of the hearing what's happening and why. Address any earnings or other pertinent issues and what arguments that you're going to be making. So for example, if amounts earned after the alleged onset date arose to the level of SGA, but really would amount to an unsuccessful work attempt, you're going to want to raise that argument in the brief. Or if the amount reflected in the earnings statement are, as is commonly the case, from short-term or long-term disability or DFAS, Department of Defense for a Veteran, indicate that as such. It's not earnings, it's benefits. And try to obtain and submit proof that would confirm the same, so that, again, the judge knows this ahead of time. This will end up saving time for the hearing, and the judge will appreciate it. They're going to come to know you as someone who is prepared and trustworthy. Now, of course, your brief should also indicate if there was any prior ALJ decisions or other procedural issues and how you are going to be dealing with that. So, for example, are you arguing that there has been a significant worsening of your client's condition and/or new impairments such that they are now not capable of sustaining any level of SGA since the alleged onset date for this case, tell them that. Now, my pre-hearing briefs are not terribly lengthy. They're usually around 2 or 3 pages, and you're going to want to draw attention to the critical medical evidence without regurgitating the entire medical file. It's already in the record. Cite to MRIs and objective test results. Include any hospital visits. Highlight severe mental impairments if that's applicable when they are routinely noted in the treatment records. And also be sure to provide citations for the judge to follow. Always make note of any medical source statement and provide an argument as to why the judge should find that statement to be persuasive, considering the factors we've covered. In the end, your brief should provide your theory of the case, supported by evidence that shows that your client is disabled, considering the 5-step sequential evaluation process. Also make any listing arguments, as well as step 4 and 5 arguments like we discussed, and provide some rationale there. Remember IRAC that we learned in law school? Use that to help give some reasons as to why the ALJ should find your client unable to perform any level of work and ultimately should be found disabled under the law. Another question regarding medical source statements and listings. Advice on getting them completed in the first place. So I find that we have better luck in obtaining a medical source statement, especially one that is more detailed and more supportive of the client's case, when the client or patient asks their own doctor or medical provider directly. So I will also provide copies of the medical source statement template to the client, and I'm going to communicate that with the client so that they know what is needed regarding their limitations. Also, you're going to want to let them know that these documents, these medical source statements, they're not required, they're not mandatory, and therefore we cannot force the providers to complete them. But if they are so willing and so kind to be willing to complete one of these medical source statements for their case, then it could serve as additional evidence to help prove disability in their case, especially if they are persuasive for the reasons that we've covered earlier. Now, you'll want to note that sometimes there's consultative examinations, or perhaps there's a medical opinion by a doctor at the initial level at DDS. Those will have a medical source statement of some sort, typically involving the claimant's limitations. So having the client's doctor's own medical providers or specialists complete a detailed medical source statement for them, for their case, could be helpful, especially if it is found to be more persuasive or most persuasive in their case. So for example, you could draft a medical source statement that would encompass the criteria regarding a listing. You might find that you commonly handle cases where your clients have back pain and that they may have medical documentation that indicates signs and symptoms similar to the criteria of one of the listings. Again, this is so important that you familiarize yourself with them so that you know what they entail and when you can make that argument. So take a look at listing 104 regarding disorders of the spine, for example. And you can outline the criteria required on a template for the claimant's physician. Ideally, a pain specialist or orthopedic doctor, perhaps even a back surgeon, or maybe all of the above. or it could even be done by the primary care physician or nurse practitioner, keeping in mind, again, those factors we've covered. The physician can review the template and they can indicate whether, in their opinion, the criteria for the listing is met or medically equaled in terms of symptom severity. So listing 104 first requires evidence of a disorder of the spine, such as degenerative disc disease or spinal stenosis, that results in compromise of the spinal cord. So you will want that medical source statement to ask the physicians to specifically address whether there exists evidence of those findings, as well as whether parts A, B, or C are met or medically equaled. Now you can simplify your template by copying that criteria of the listing, such as evidence of muscle weakness, positive straight leg raise, inability to ambulate effectively, and there are more indicated in that listing. And asking the doctor to indicate which, if any, parts the patient may meet or medically equal and why. How did they come to their conclusion? Now, finally, when drafting a medical source statement, you will want to keep in mind all the factors we discussed, review the code, review the regulations, and you should include questions that indicate, for example, the frequency and length of contact with the doctor or the treating patient relationship. The statement should also reflect their specialty in the field and document the patient's diagnosis, prognosis, response to treatment, and any relevant symptoms, such as pain or weakness, numbness and tingling to the extremities, for example, or fatigue. And of course, the limitations are critically important. We talked about exertional and non-exertional limitations, and you can include those in the medical source statement for the doctor to indicate which apply for that specific patient or client. You ideally will want to focus on questions that are geared towards the patient's impairments for which they have personal firsthand knowledge or experience of, and treat the patient for or have a specialty in. In other words, you won't want to ask about mental impairments or go on about mental impairments if that's not really applicable, and the other way around, right? You won't want to go on about physical limitations in a template going to the client's treating psychiatrist or mental health therapist or psychologist, for example, who treats their mental impairments. So those are just a few tips I hope you found helpful. Thank you again for joining me today. I hope that you were able to take away some useful practice tips and guides to enhance your practice and the way that you help your clients. You can contact me with any questions or for help with any templates or documents that I mentioned here, whether it be a brief or a template for a medical source statement. I'm happy to help. You can contact me through my website listed there. You can also find my email and contact information on my website, disabilitylawgroup.com. Thank you again, and I hope you have a great day. Stay safe.
We hope you enjoyed your CLE. At the conclusion, please click the link provided. You will be asked for a confirmation of your email and registration information. Please choose your state and enter your bar number and proceed to the evaluation. Once the evaluation is complete, you will see a confirmation page indicating credits and certificates to be delivered. Thank you again for joining us at ProLaw CLE, and please check out ProLawCLE.com for other course offerings.